Thanks everyone for joining us this morning on today's webinar. For those watching live, this is Can I Post This or Share This or Use This? The topic of putting creative content online. Today's presentation is being offered through CBCA and our Colorado Attorneys for the Arts program. And our speaker will be Dave Ratner with the Creative Law Network. This presentation will be recorded, so if you're watching it afterwards on YouTube, hello to you as well. And this is really an important topic. As some of us were chatting before we got started today, this is a question that hopefully you have been asking for the last 10, 15, 20 years, as long as we've had the internet. But as we know, this pandemic and lockdowns and shutdowns, and there's been this surge of creative content that has been put online, from virtual dance classes to resharing old recorded theater performances to house concerts being streamed online, and people putting their artwork online and doing digital exhibitions, which raises a whole nother host of questions about copyright usage and licensing and what you originally had the rights to and if you don't anymore, or how does that work in all these different ways. So that's what we're gonna talk about today. We have a really full and packed presentation, but the reason we decided to do today's presentation in sort of the meeting mode is because we really want to hear your questions. We know you probably have some specific examples of what you're going through, and we'll try to answer them in ways that are sort of applicable to everybody and provide some of that general legal guidance. And that's what CAFTA does. CAFTA is dedicated to providing legal education, and when we can, direct referrals to pro bono attorneys to help artists and creative organizations get the help they need around some of these really nuanced legal questions in the creative sector. So that's what we're here to do. A few more housekeeping items related to Zoom. You're all muted upon entry. Please stay that way for now at least. That helps eliminate any background noise, dogs barking, what have you. We want to make sure you can all stay focused on the presentation and not have as many disruptions or distractions. With that, we invite you to also turn your camera off, so you could just focus on the presentation. You don't have to, but again, I think that'll help us all stay really focused again on the conversation. And along those same lines, we are here to answer your questions. We want to know what's on your mind and what prompted you to listen to this presentation. During the bulk of it, we ask you to direct those questions to the chat feature. You can chat to Dave directly, our speaker, or to everybody. So we can all see your questions. He'll be keeping an eye on that throughout. So that's a good way if you have sort of questions that come up during the presentation, instead of unmuting yourself and interrupting, just to put it in the chat, and that'll help us moderate those. And then towards the end, depending on how much time we have, we can do sort of an open forum. Cool. All right, well, we have a full room and folks from all over Colorado joining us today, which is one of the beauties of these virtual presentations. So I will go ahead and stop sharing my screen and turn it over to Dave Ratner with the Creative Law Network. Dave is a arts and entertainment, creative industries attorney, focusing on all the different areas of law that are relevant to the creative sector. He's also the chair of Colorado Attorneys for the Arts, and just very involved in our local arts sector. And we're grateful for him to spend his morning with us and share this really great information. So Dave, I will stop sharing my screen so you can pull up your presentation. Thanks.
Sounds good. Thanks very much. Appreciate it, Meredith, and good to see all of these folks on joining us today. Really, really cool. I'm really excited to do this and and hear about what what your questions are. Like Meredith said, if you can keep the questions in the chat, which I will have to figure out how to bring up here, then then I will be able to make sure that I'm seeing what you guys are seeing. Unfortunately, I'm not seeing it. There we go. Okay. Um, and this is a topic that is obviously has a lot more relevance in the recent months, and something that we've been talking about internally with Colorado Attorneys for the Arts, because we see these issues popping up for clients that are coming through CAFTA, through Colorado Attorneys for the Arts, and also coming through our firm. We obviously we've been dealing with this a lot from the get-go. As soon as we stop doing things in person, we start putting everything online, obviously. And I see we have a really interesting group of people here, folks from the libraries, folks from festivals, folks from presenting organizations, which is great. So I'll try and make sure that we're pushing this talk in directions that's going to be helpful for you. And what a lot of this has to do with copyright. So we're going to talk a lot about copyright and link that in to what we can post online, what we can share, and how we can use content. Really briefly about myself, just a little background. As Meredith said, I run Creative Law Network. It's a law firm working with creative people and businesses. In my former life, I was a band manager. I was a tour manager, actually. I was on the road with a band and learned all about the music industry from that side of things, and learned about the issues that were facing musicians, and then learned about the issues that are just facing the creative sector in general. In working with my clients as this pandemic has unrolled, and as we've changed the way that we do things and everything that we do, it's really, I've noticed how we've had to adapt so many things to the online arena. And really, these are things that are not new. It's just that we are doing it more, and more of us are doing it, and more are running into these issues. And I imagine most of you are here because we want to make sure we do things right. Appreciate that. That's obviously our job as lawyers, is to make sure things go right, generally. So we can jump in and just talk about some of what underlies the question of, can I post this? What this is really about is copyright works. Okay, so online content, whether it's video, music, two-dimensional images, all these things are copyrighted. Copyright protects creative works, and we'll talk about that. And so even we can use this example of this presentation involves a copyright work of these slides that you're seeing are copyright text that I've created. The voice, my voice and what I'm speaking, and the dialogue that I'm creating, or the monologue I'm creating, is also protected by copyright as we record this presentation. And so to the extent that you and your work are creating a video, you're going to be using different pieces of content, whether it's audio or visual, and making sure that under the assumption you haven't personally created all those works, we may need to have rights to those different pieces of work. So we'll talk about, like I said, the online content is these independent copyright works combining to create a new copyright work. And we'll talk about just a little bit about what is copyright. Copyright protects an original work, and we say that it's permanently fixed in some way. Fixed means it is recorded, is written down, is captured somehow. It protects literary works, musical works, dramatic works, choreography stuff on stage, pictorial, graphic, and sculptural works, so 2D and 3D art, as well as motion pictures and videos, and even architecture. So basically, this is the scope of what's creative and the scope of what's protected by copyright. And it's important to think about that because in the example Meredith was giving about perhaps an online dance lesson or a dance recital, well, that choreography that is going on during that presentation is protected by copyright. So to the extent you are going to be running your dance class online and you want to show a video of someone else's performance, that's protected, and we would need the rights to do so. So these are all the things that are protected by copyright. Well, the main question that comes up out of that is the rights that are granted by copyright. What that means is, if you own a copyright, you own the exclusive right to manipulate, to exploit, to use the copyright. So if I own the rights to a piece of music, I have the exclusive right, which means I'm the only person who is allowed to reproduce it, to prepare derivative works of it, to distribute it, to perform it, to display it. Performed by digital audio transmission is a little more technical than we probably need to get into. But the point of all this is that if you do own a copyright, like I said, the piece of music, the two-dimensional artwork you painted, the dance performance that you did, you have the exclusive right to make copies of it or to use it to distribute it on the internet, and to perform it, to use it in different ways. And so as the copyright owner, that person is the only person who has that exclusive right. No one else can use it. So unless you own that copyright, you're not supposed to be using it, without permission anyway. We'll talk about that. So that leads to the question of, well, who owns the copyright? In general, the default for the law is that the author or the creator of a copyright is the owner, or what we call the claimant in legal language. So that means that if I write a story, if I record a song, if I created, choreograph a dance, I own that copyright. And we oftentimes get into, if multiple people co-create, work together to create a co-authored work, well, then they're going to co-own that work. The exception is something called work for hire. Work for hire is if an employee creates something within the scope of their employment, then the employer owns that copyrighted work as a work for hire. That's what work for hire means. An example would be a staff writer at a newspaper writes an article, the newspaper is going to own that article, the copyright in that article. Work for hire can also be contracted. So to the extent, let's say you hire a videography company, or you get a video production company, and you hire that company to create a video for your business, for your organization. And you put in the contract, we are hiring you to create this video, and we own this video. That can be a contracted work for hire. So it's either by an employee or via contract, but it does affect the ownership. And really important to know that the ownership of copyright ownership can only be transferred in writing. So there can't be a handshake deal, so to speak. And that is important because a lot of people say, oh, well, yeah, I hired him, but he said I own it. Unfortunately, by the law, it has to be in writing. So important thing to know there. Let's see. Sorry, moving things around here so I can make sure I'm seeing everything. So the idea is, how do we use someone else's copyright? Okay, you own a copyright. I want to put it in my video. Well, we have to get a license. A license is a grant of rights. It's kind of like renting the rights in the sense that somebody owns it. You're going to let someone else use it. So in the example where I wrote some music, I record that music, I own the copyright in that music, and and you want to produce a video, you want to use my music in that video, you just need to get a license from me that says you can use that music in the video. Licenses are not that simple, actually. They're not as simple as, oh, you can use it, because we have to talk about how long can you use it for, or how much of the song could you use? How long can you use it for? Can you post this just on YouTube, or can it go on your website and Facebook as well? Is it only, for a set geographic area? Can only use it in the US, or can it be worldwide? These are all some of the things we talked about in a license. And so what we want to have things in writing. A license we want to have in writing as well, so that we know exactly what we can do and how we can do it. And I do see some questions. I see a question here. I'm just going to keep on going. I promise to get the questions in the chat. Thank you for that. I think we'll get to answering that question, the first one I see anyway, as we get a little bit further through this. So licensing is really important. If you're creating online content and you don't own everything that you need to use, you need some music, for example, that you don't have rights to, we need to get a license to that music. So what does a license look like? Well, the two main types of licenses that are going to come into play here are what we would call a direct license or blanket license. The direct license is the example that I just gave, where I own the music, you're making the video, you come to me, I give you a direct license for this one piece of music for use in your video. Fairly straightforward, and again, it does vary. Or rather, the terms vary and we have to be specific. But what we run into a lot of now, as we're all out there looking, we're saying, I got to make this video, I need some music, I need some background, I need all these things. We look at what are called blanket licenses. Or there's other terms for them, but these basically refer to is licenses that come from an organization, a company. The most common thing we see is for photos. There's a lot of what we call stock photography. And now there's stock music and stock video and stock backgrounds. But basically it's a website, generally it's a website that has countless examples, countless things you can license. And you can go to that website, you can choose what you want. Generally you have to pay something, sometimes it's free. And the website says, okay, thank you for signing up with our website. Thank you for paying our fee, whatever it is. And you can now use this content. There are a number of things to be careful of here. The most important one is what that license says, obviously. But I mean, does that license specifically fit your use? And what we want to do is we want to look at what it says. So we're talking about these blanket licenses where we want to make sure we read the terms of use carefully, because sometimes the most common thing I see in these terms of use is it'll say, yes, you can use this music in your video for non-commercial purposes only. And I see most of us are here, when you signed up, you listed your organization, most of you work with a business or an organization that is arguably commercial. So it's one thing if you want to use this music in the background of a little video you're going to share in a private YouTube link. It's very different if you're going to use that music for a video that is for your business that has an arguably commercial purpose. I will say these terms of use can be complicated. This is one of the things that we do as lawyers is we write these terms of use, we read these terms of use, and they can be a little complex. So you do want to make sense of them and be very clear. Okay, I'm going to this website, I'm getting permission. It's the right thing to do. That's great. But let's make sure we have the proper permission. Sometimes there are different levels of licenses. Maybe you're paying $5 or $20 or $100. Well, those different levels are going to grant different rights, the extent of rights. Sometimes, you can use it in a particular instance, but you can't make copies, or you have to give attribution. There's a lot of conditions that can be applied. And we want to be aware of those conditions, make sure we're not running afoul of the rights that are being granted. I had a client who works in the arts, is very respectful of artists' rights, and found just a little graphic, just an image that could have been on a bumper sticker. And he found it on a site that said, this is free to use. So he figured, okay, well, that's great. I can use it. And he put it in a blog post. It wasn't a big deal. It was just the header of a blog post. Now, again, that is someone else's image that we're using for our online content. So we need to have a license, or we need to know. And he said, well, the website said free to use. He didn't look more carefully to see that it was non-commercial use. And furthermore, the website said, we don't promise that we own this. The website said, people throw stuff on our website all the time. You can use it. We just don't know if we have the rights to use it. So there's a lot of tricks to this stuff. And the best guidance I can offer is just to make sure you have the rights to the best of your ability, to look carefully, to read carefully what you're going through. And if you're not sure, probably best not to use it. I should preface this whole conversation or presentation by saying we're not providing legal advice here. I am explaining the law. I'm explaining what the parameters are. But legal advice is really a one-to-one relationship. And that is why CAFTA exists. That's why my law firm exists, so that we can provide that one-on-one advice for your specific scenario. But this whole presentation is more about the parameters, the constructs of what we can and can't do to help you all make those decisions and find that guidance. So I think that one of the things, the other side of licensing, the other side of finding things on the internet is when we find things that someone else has posted, or that we're posting stuff. Because a lot of people say, oh, well, will say to me, I've heard this before. People say, oh, well, someone posted it on Facebook, so I just right-click saved as, and now I can use it, right? Or if I post my video, does that mean I'm giving up my copyright? Well, neither of those things are true. Posting does grant a license. If you post something on Facebook, let's say you take a photo, so you own the copyright in that photo, and you post it on Facebook, you're granting a license to Facebook to use that photo. And Facebook has terms of use that you can read that are going to say what they can and cannot do, what rights you're granting them, but what rights you're not granting them. They can post it, they can use it, maybe in their, obviously in the feed, but they can't take your photo and put it on a billboard advertising Facebook, for example. It does not transfer ownership. So posting a video on YouTube does not transfer ownership of the video to YouTube. Posting a photo on Facebook does not transfer ownership of the photo to Facebook. It does allow others to repost. That's kind of a wrinkle in there, right? If you post your photo on Facebook, no one is allowed to just grab it and go use it on their website or for their commercial purposes. But to the extent they share that posting, that is a repost, that is a reuse, the duplication that is allowed by the terms of use. So these terms of use of websites do factor in pretty significantly in figuring out what we can and can't do. And I think that most of us have gotten so used to social media that we don't think about these things, because you're all fortunate enough not to be copyright lawyers, so you don't think about these things, and that may be a blessing sometimes. But it is a really interesting landscape, and it is changing, especially as we see, as Meredith was saying when we opened, online concerts and online all these presentations. I mean, we're seeing all these conferences that we would normally attend in person going online. So all of those things, to the extent that you're going to do a presentation that is going to be online, we have to make sure we know where those rights are, where they're coming from. Let me see if there's anything in our chat here real quick, just to see if there's anything about reposting. Have to be on the same site. Whether you can repost on the same site or a different site is going to depend on those terms of use. It's different for every website. It's different for every service. They all write their own terms of use. So that is a kind of case-by-case basis. Let's see. We will talk about music, which is a whole other ballgame. So Anthony, I'm going to hold off on that one. And press kits, considerations or concerns about widely using images, text from press kits from events. Yes. If you are hosting an event, let's say you are hiring a performer to perform an event and they give you their press kit, that does not mean they're giving you the rights to use those photos. I have had a client get in trouble for doing that. Okay, so it is important to get that permission to say, okay, thanks for this press kit. Can I use these photos, and get something in writing that says, yes, we own the rights to these photos. We have the rights to use these photos for that purpose, because just handing you a press kit does not automatically confer a license to use it for other purposes. Then you have a right to stop a production if their software concludes the music is not copyrighted correctly during a performance. Okay, so Trezi, I'm not entirely clear on this question, and I might ask you to clarify that a little bit, because I'm not sure how software would conclude something like that. So maybe you can give me a little more context, and I'll come back to that one. Okay. Let's talk a little bit more about copyright. I want to give you more background in copyright here, because you have questions about this, like, how long does the copyright last? Can I just wait a couple of years and then all of a sudden it'll be free? Copyright lasts for quite a long time. We call it the copyright term. The term of a copyright lasts 70 years after the life of an author. So if I write a song today, I own the copyright until 70 years after my death, or it will pass to my estate, and that copyright exists and persists until 70 years after my life. If it is a work for hire, it's the shorter of 95 years after first publication, or 120 years after creation. So it's a very long time. And there's a whole long history, and we could have a whole other presentation on why copyright term is so long. That's just the way it is. So a lot of people say, well, okay, then I want to find some stuff that is no longer protected by copyright. That is what is called the public domain. Public domain is when a copyright expires, that work enters the public domain, which means it's no longer protected by copyright, it's free to use. So there's examples of this are plenty of classical music written by the masters like Mozart or Bach. Obviously, it has been more than 70 years after their life. And therefore, those pieces are in the public domain. We'll talk about music specifically and why that is not always as easy as it sounds, but plenty of books as well I have a client who's republishing a book that just went out of copyright. The author, it's been 70 years since the author's death. The book went out of copyright, it's in the public domain. He's going to take the book, add a new forward to it, add some drawings, and republish that book because it's in the public domain. He can do that. So to the extent there are works in the public domain that you want to use in your presentations or in your online content, that's a much easier path. It's really important to know, though, it's very difficult, or rather it is not as simple as 70 years after the life of the author to determine what's in the public domain, because the copyright law has changed frequently, actually. So when the Copyright Act of 1909 had a 14-year term, which was then changed to a 28-year term, which was then changed to a 28-year term with a 28-year extension. And when a copyright expires is based on when that copyright was created. So a copyright created 50 years ago is ruled by the law back then and how it's been revised by the law now. So it is unfortunately not so simple to say, oh, what's the year and it's good. We can generally say that anything before 1925 is now in the public domain, but also remember, every country has its own different copyright laws. So if that copyright was created in a different country, it may not be in the public domain in our country, or worldwide. So I cannot advise you to just look for anything created before a certain date and it's in the public domain and you're fine. But public domain is a common way to find content that you can use. Another question we regularly get is, what's this thing called fair use? Fair use is a pretty complicated concept. It is something that is important in copyright law, but it is not something that's either black or white, generally. Because someone will say, well, I want to use this, isn't it fair use? And fair use is an analysis. It's not just a check the box and yes, it's fair use. So I'll explain a little bit about this analysis, but again, that's a whole other presentation. So it is also important to understand that fair use is a defense to infringement. And what that means is, if you are accused of copyright infringement and you get sued and you go to court, your defense is, hey, it was fair use, I didn't infringe that copyright. But it is not an affirmative right. You can't say, I'm using this as fair use. This is a bit of a legal hair that we're splitting, or that I'm splitting. And I don't expect or want to go too far down this path, because again, it's quite complex and there's literally thousands of cases of lawsuits and cases about this. Millions of pages have been written about it. But I explain it because it is something that pops up regularly. And in some cases, the use is fair. We do find fair uses. It's just that it's a case-by-case analysis. So every time there is a third-party piece of content that you are interested in using, and if you say, well, I think this is fair use, we have to analyze that and say, we evaluate these, what we call factors. There are 4 fair use factors. And again, this is case-by-case. So a judge will take the evidence in a infringement suit and evaluate on these 4 factors. We say no one factor is dispositive, so just proving that it's fair use on one factor doesn't affect the others. And as you can see, there's 4, there's not an odd number, so you may win on 2 and lose on 2, and then the judge gets to decide, was this a fair use? But I will talk about them briefly, because you may be looking at a piece of content and saying, well, can I use this? Can I not? Is this fair use? My answer would be, you really should talk to a lawyer. That's why CAFTA is here. That's why my firm is here. But understanding that part of this presentation is to give you the background, so I want you to understand how we make these decisions. The purpose and character of the use is generally, one question we ask is it a transformative use? So are you using a photo as a photo, or are you making a painting of that photo? Are you manipulating the photo? Are you transforming it in some way? What's the purpose of your use? What's the character? The nature of the copyrighted work, if you are taking an excerpt from a textbook, something nonfiction, that is given less protection, it's more permissible than from a work of fiction, something creative, something that someone had to invent more out of their mind. So the nature of the work that you're borrowing from, that you're claiming fair use on, is one of the factors. The amount and substantiality of the portion used is important. So whether you're taking a line out of a book or a paragraph or a chapter, quite significant. And the effect of the use upon the potential market, the money basically. A lot of people say to me, well, I'm doing this thing, but I'm going to give it away for free. So that's got to be fair use. And it just doesn't work that way. It's a factor, whether you're giving it away for free or whether you're taking money out of the pocket of the person who owns the original or not is a factor, but it doesn't just make something a fair use. As I said, we don't regularly rely on fair use. It's not something that we can always say, oh, well, that's fair use and you're fine all the time. But it is something I want to make sure to cover because it is something that comes up quite regularly and is very relevant to the idea of we're using other people's content. How do we use that content? When is it permissible? When is it not? Let's see. I'm going to go back to the chat questions here real quick. A few venues now have software that will alert the production operators that certain music is copyrighted. Okay. I have not interacted with this software. And the reality is, I mean, the question of whether a venue has a right to stop a production is between the parties involved. And so I think there should be a contract for that production. And that contract should address whether you can stop a performance. How about specific formats of copyrighted work? A new high definition scan of public domain photo. Does that scan have its own copyright? There's a very good question from Greg about a new version of an old work. If you have added something copyrightable to the work, to the public domain work, you own your copyrighted or your copyrightable addition, your copyrightable contribution. I was using the example of my client who is taking a public domain book and adding a foreword, adding illustrations, adding a new cover. So he will have copyright in those additions, those new copyright works that he's added to the existing work. He will not have any copyright in the original book. There's no protection that he gains in the public domain work by adding to it, but he certainly has rights in the things that he's created, that he's added to the original. We also see this when we create what are called derivative works. So taking one work and transforming it into something else, taking a book and making it into a movie, or taking a photo and making a painting of it. To the extent that the creator of the derivative work adds to the original, they own the copyright in addition to what they contributed to the derivative work. Now you do need permission to create a derivative work. If I write a book and you want to make a movie of it, you need my permission. But I wouldn't have ownership over your movie. I would still have ownership over my book and the story and the characters and things I created. So that's how that works with public domain. One thing I want to make sure we talk about is music, because music copyright is very complicated. It's I like to say it's twice as complicated because there's two copyrights in every piece of music. There is a copyright in what's called the composition, which is basically the music and lyrics, what's written down, what the songwriter creates, basically the composer creates, and the sound recording, or we call the master, is a completely separate copyright. So to the extent that I wrote a piece of music, I would own the copyright in the composition. And then if you went and made a recording of that piece of music, you would own the copyright in that sound recording, in that master. Completely separate copyrights. Now you would need my permission to put my composition in your recording, and that's a little technical, but the point is that there's two separate copyrights. And that is really important. I mean, I was using the example briefly where I said, well, if you're using a piece by Beethoven, that's obviously in the public domain. Well, the composition that Beethoven wrote is in the public domain. But if the Colorado Symphony made a new recording of that Beethoven piece, the symphony would own, or arguably own, that recording. So you can't just go use that recording without the symphony's permission. You don't need to go get Beethoven's permission. No copyright in the composition, but there is still a copyright in the sound recording. So that is important. And it's hard. It's sometimes hard to divide these things in our mind, right? Because if you're listening, you turn on the radio. Those of us that listen to radio, you turn on the radio and you hear music. You're not thinking about the songwriter and the recording artist, and whoever owns the copyright in the composition versus the master. But again, I have the blessing and curse of doing this for a living, and I think about these things, and these things are very clearly divisible. So that's really important when it comes to music licensing, right? Because if you say, I want to use this piece of music in my video, I want to use it in the content I'm creating. Well, if we want to use music in any moving image, so that's a video, movie, TV show, video game, anything that has a moving image with it, we have to get what's called a synchronization license or a sync license. So I think a lot of the content that we're all creating and posting online, a lot of this is video. So it does have a moving image. It would require a sync license to include music. If you are going to include music in your video, in your moving picture, you need a sync license from the owner of both the composition and the master. This can be complicated. Just even tracking down these owners can be complicated, but it is really important because it is a very expensive license to get, unfortunately. This is why stock music is very popular. Even re-records have become more popular because the licensing is expensive. You do have to get a direct license from, if you want to use a piece of well-known music, something that people recognize, you're going to have to go to the owner of the composition rights, and then go to the owner of the master rights or sound recording rights, and get licenses for both of those things. I mentioned that they're very expensive because I regularly work with clients who say, oh, I want to use the Beatles, and I want to use the Rolling Stones, and I want to use some Nicki Minaj, and those three, using one of each of those is six figures a piece to begin with. This is just the marketplace that we have for music these days. It is hard to get these licenses. They are expensive. I can't give much more of an explanation than that, except that, and I understand it's frustrating because a lot of people, it's the music we know, it's the music we want to use, and it's just not that easy, unfortunately. So getting the rights to use music in our videos is something we want to be very, very careful of, because it's something that is easily discovered. And I will talk a little bit about the technology that is now out there that I am familiar with, that finds content in postings and gets it taken down or worse. And music is a very easy one that gets tracked specifically on YouTube, but also on Instagram, Facebook, where if you are using someone else's recording, there is technology that will find that music, that recording of that music in your video, and the video may get taken down, or you may get a worse situation than that. So I'll talk a little bit more about music licensing, specifically what we call a public performance license. Some of you may have heard of these performing rights organizations. ASCAP, BMI, and CSAC are these PROs, these performing rights organizations. So when a piece of music is performed, and performed in copyright sense means not just performed live, but played on the radio, played in a movie, played over a jukebox, anywhere that the public can hear it. That is the performance of a composition. This is relevant because when you get a synchronization license, that does not also include a performance license. And I feel like I'm making this sounds very complicated, and that may scare you away from using music that you don't have a license to. That may be a good thing that comes out of this. But the point is that these performing rights organizations, these PROs, license the public performance of music. So every radio station in the country has to have a license from the PROs so they can go perform this music over the airwaves. And then they pay a license fee to the PROs. The PROs pay the owners of the copyright, pay the songwriters, basically, for the use of their music. This is also relevant because to the extent that you are creating something that includes music and you are going to broadcast that creation, that is a public performance. So we want to be aware of where that licensing, what licensing we need to procure, where that licensing lies. Some services have PRO licenses like YouTube. So putting something on YouTube does not require you to get a PRO license. But it's something to be aware of because it is part of the one of the steps in using music in something that you are in content you're creating and publishing. There's also something called a mechanical license. Mechanical license is the license to mechanically reproduce a composition in a recording. So when you are making copies, when you are showing a video over and over again, you are replicating, and that may require a mechanical license. All these things to say that there's a lot that goes into music licensing, and it's just a complicated area. And going back to talking about stock music, to the extent you go to a website and say, I just need some nice background music, I'm just going to license something stock, don't have to be recognizable. Check those terms of use for that stock music website to make sure that it's giving you the rights you need. Chances are it should, for commercial purposes, but it is just, these are all kind of pieces of the puzzle that that go into creating content that we properly license, that we're using properly. We have a question about classical compositions. So give me a moment while I read through the question so I can answer properly. I want to record an X long, not in public domain, really private. Okay, so recording 2 minutes of a classical piece in a video that will be private and sent to a limited group of people. That doesn't alleviate the need for a license. Okay, it is, again, whether we're charging for it or not, whether it's open to the public or not, doesn't change the fact that somebody owns the right to that music and they own the copyright. The copyright gives them the exclusive right to be recorded. And so you can't just go and use that copyright without their permission. You can get a license for it, and that would be a proper thing to do. But let's see, I think that the owner of the sheet music isn't relevant to making the recording necessarily. I know that for orchestras buying sheet music, that there's usually a package license that comes in with buying sheet music for a performance. And that is a contract, basically, that when you buy sheet music for a performance, it allows you to give a performance. Maybe it allows you to make a video recording. It just depends on the terms of that license, which is a contract, the terms of that contract. So these are things that are very specific to the situation. But I think the overall, or rather the underlying line that I can draw through all this is that you need a license to use someone else's content. So if you're using a piece that's classical or not, any piece of music that you're going to record for use in a video, you would generally need rights, to make that recording and to use it in your video. So, and Anthony wants to know if we play a recorded song for an intermission break. Yes, that would require licensing too. I mean, the thing is, again, you're taking someone's copyright. Okay, so someone has a copyright in this music. You're taking that copyright and you are using it, right? You're replicating it. You're putting it in your video. You're using it in some way that needs permission from the owner. And that's the underlying thing for all of this. So I do want to talk about some exceptions. And YouTube is one, because everyone says to me, there is so much music on YouTube, they don't all have a license. And you are absolutely right. That is true. YouTube has a particular setup based on basically the size and breadth and reach of YouTube. And also because YouTube was sued. There's a very long and expensive and well-known lawsuit, basically Viacom, which owns a lot of video content, right? They own TV stations, movies. Early on in the life of YouTube, Viacom sued YouTube because they said, you have every one of our sitcoms on there, you have every episode, you have all our movies, they're all on there. You are contributing to the infringement of our work. And they sued them in federal court. And this went back and forth for a very long time because YouTube said, we are innocent, people are posting stuff, they're the ones that are guilty, we are just providing a service. And what came out of it is they created something called their Content ID system. And what that does is it basically scans everything that is uploaded to YouTube to see if it is infringing a piece of content they're aware of. They have a database of every piece of music out there, not every piece, all the major recordings out there, all the major movies, all the major TV shows, they have that in their database. And when you upload something to YouTube, they check it against everything in their database. And if they do find a hit, they can do one of three things. They can have it taken down, or rather the owner can tell YouTube, the owner of the copyright can tell YouTube to do one of three things. They can have it taken down, they can let it stay up, or they can monetize it. So there's plenty of content owners out there who say, yeah, someone wants to put my music in their video, let it up there, monetize it, send me the check. It's a pretty easy way for it to work. And not every piece of content gets caught by the content ID system. If you make your own recording, let's say you want to make a recording, a reggae version of a bluegrass song. Okay, so it's a Del McCurry song and you make a reggae version, chances are their content ID system isn't going to find it. And there is not a human being sitting there at YouTube checking every upload. So you may get away with that. It doesn't mean it's it doesn't mean it's legal. It means you got away with it. And that doesn't prevent them from taking it down later. It also doesn't prevent them from suing you for infringement down the road. And one thing that regularly happens, unfortunately, is that a piece of content sits there for a long time, gets a bunch of views, and then the content owner comes along and says, hey, you've been using that the whole time. You didn't get a license. You infringed our work, and you're guilty. We're going to sue you for infringement. I'm actually dealing with right now. I represent a business, and they, in the early days of YouTube, they had it doesn't seem that long ago, but it is in the world of the internet. So more than 10 years ago, about 12, 13 years ago, they had an intern who said, hey, there's this thing called YouTube. I'm going to make some videos to promote our business, and I'm going to throw them up. We're going to start a YouTube channel. So he started this YouTube channel. He put up 10 or 15 videos, and he used Michael Jackson. He used the Talking Heads. He used just very well-known music. And they sat there. They got a few hundred hits in 10 years. I mean, there weren't many videos, and no one was seeing them. And the business forgot about those videos. They started their own YouTube channel a few years ago. And about 6 months ago, they got a letter from the lawyers representing Sony Music and Universal Music. And they said, hey, you've got this video channel over here that promotes your business, that uses all this music that we own the rights to, and you owe us, we're going to sue you. And if, we agree to not sue you if you pay us $300,000, but otherwise we're going to sue you. I'm handling those negotiations right now. We'll hopefully not have to pay $300,000, but it's an example of why we don't use music we don't have the rights to, even though it's innocuous. It doesn't seem like it's a big deal. YouTube will catch it. Everybody does it on YouTube. It's just an example of how these things go. And we see a lot of this use, so we feel like it's okay, but that doesn't actually make it okay. The fact that it's allowed, or that it is happening, doesn't make it legal. And I think it's also important to understand there tends to be a gap in copyright law between the letter of the law and the application of the law. So the letter of the law clearly says you cannot use anyone's piece of music for any purpose without their permission. And in application, we do see a lot of those uses going on. We do see a lot of live streams. And I want to specifically address this because ever since we stopped having live performances of music, we see a lot of live streams going on. A lot of them, I mean, great charity events, all great things that all need to be licensed. Are they getting sync licenses for all these things? I can't say. I can say probably not. Is anyone getting sued right now? Haven't seen a lot of that, so a lot of people are getting away with it. Does that make it legal? It doesn't. But it makes it something that people are doing, and you may say, I'm willing to take the risk. I'm willing to do my live stream, take the risk that someone's going to come after me, or issue a takedown, because I don't see anybody else doing it. They're not going to come after everybody. And that is a risk you may choose to take. I think that, without getting too philosophical here, a lawyer's job in a lot of ways is to advise their client on the risk, right? To say, here's what the law says, here's what people are doing, you can evaluate the risk. And we do see a lot of streaming going on without licensing right now because there's just so much content being created. But the law says that any use of any synchronization of music with a moving image needs to have a license. So that's what I can unequivocally say is that's what the law says. Another exception to talk about is something called Creative Commons. Creative Commons is what we call an alternate licensing scheme. It's an alternate to copyright, basically. It grew out of the open source software movement, basically, saying there should be open source lots of things. There should be open source photos and videos and images. And so I don't want to do a whole lesson on creative content. Again, that could be an entirely separate presentation. Creativecommons.org is a very informative website I can tell you about. Basically what it is that if I own, let's say I own a photo, but I think, I'm okay with anybody using this photo under certain conditions. So those conditions are listed by a Creative Commons license. I can say, I'm going to post this with a Creative Commons license, just a stamp on the, basically saying, I'm going to say anyone can use this as long as they give me attribution, or as long as they use it for non-commercial purposes only, or as long as they grant the same license to everybody else who wants to use it, who wants to use their work that uses my image. So sometimes we look for, in creating content, we look for Creative Commons licensed works. We look for photos that say, this is Creative Commons, this can be shared using a Creative Commons license. It's a very big twist on copyright. It's a very different way of looking at it, but it is something that we do see with some regularity, and something I know everybody on this, or a lot of folks on this call are trying to figure out, how can I create this content and not have to get licenses everywhere? Creative Commons is an option. I did talk about live streams being not an exception, even though I know that we're seeing a lot of it. So even though it's not a legal exception, it is something we're seeing a lot of, and I understand that. So that basically, those are the exceptions I can think of, but you guys find others. I'm happy to discuss them. So really, this is, I know this gets us to a point of like, well, now what? What do I do? Because I need to create this content. We cannot do things in person for the foreseeable future. So how do I do this? And it's basically just thinking about the copyrights you're using. We've talked about I've mentioned a number of different ways we can use other people's content, whether it's public domain, whether it's getting a license, whether it's Creative Commons. So it's really just making sure you have the rights or can get the rights. And it doesn't have to be super complicated. I'm trying to go through all the scenarios, and that may be throwing us in directions that sound complicated, but it doesn't have to be, or expensive for that matter. You can see there are countless ways to create permissible content. It's just you want to make sure that you have the rights to the content that you're using, and we call that clearing the rights. So you want to clear the content that you're using. So getting back to kind of trying to pull this back around, then we can start some Q&A, which I think will be really helpful. The can I post this is yes if you have the rights, and yes if you license the rights. If someone else posted it, maybe, because reposting is a good example, right? Or Creative Commons has been posted with a Creative Commons license, maybe we can use it. Yes, if it's a public domain, we want to be very careful about what is and is not public domain. And maybe if it's fair use, because fair use is, like I said, a complicated construct that we want to make sure we are being careful around, and not just saying, oh, it's fair use and we're fine. So overall, I just want to make sure to convey, and I think you already have heard this enough to always think about and respect other people's rights. You are creating copyrighted content when you create whatever you're thinking of posting or sharing. And you don't want people using your stuff, your creations without permission. Similarly, people don't want you using their stuff, their creations without permission. And we maintain that, and it tends to keep copyright in line. So that is everything I have prepared. But I think I know that we can, or I want to make sure we do open it up for questions. And I think, I don't know if Meredith, if you want to come in and kind of help moderate that, if we're going to have people raise their hand, I will let you tell me how you want to do that, and we'll be able to answer as many questions as I can.
I'd love to help. Thank you. And I wrote down some of my questions of my own, or just
Oh
other
boy.
things I know I've seen other groups do as well. So I feel like you did a good job of catching anything in the chat. I think there was something earlier on in the chat about educational institutions, whether it's an educational institution using material, or if you're using material for an educational purpose. Is there any different rules there?
Okay, I'm looking for that, but generally there is an educational exception to copyright, what we call the educational exception. So we can use for an educational institution can use for an educational purpose, but it does have to be an educational institution to qualify for that exception. So to the extent I say, this presentation is educational and I'm going to use a whole bunch of other people's content, it does not work that way, unfortunately. I do not run a school. CBCA is not qualified as an educational institution under the law anyway. Now, we could start running classes, and we could make sure to check the boxes under the copyright law that qualify for the educational exception. But it does have to be, there are certain qualifications that make an educational institution. That doesn't mean just schools. There are, I mean, depending on how we define school, basically. For example, I've helped a religious organization qualify for the educational exception because they were teaching within their church. So that can function, but it can't just be, I'm teaching, so therefore I can do whatever I want.
Yeah, and I know there are some cultural organizations that are on right now that education is one of their primary sort of charitable purposes, education through the arts or about the arts.
Okay. Yeah. I mean, I think it is a maybe. It is a definite maybe. It is. Here's the thing: is that this is. I hate to say this is why I have a job. This is what keeps us busy, is figuring these things out. I mean, so what we do is, in this situation, we go and look at the copyright law, because the copyright law specifically, I mean, I think it's section 110. It does specifically say what qualifies. I mean, the educational exception is written. So we just have to talk about the specific facts of the situation, how it applies to the statute. That's how we come up with an answer.
Got it. I have a few other questions that I know I would like to ask, but other folks here, you do have the opportunity at this point, if you want to turn your camera back on, and I think you have the ability to unmute yourself, maybe or maybe not. But I know
I think they do.
Turn your camera back on, we'll unmute you. And we'd love to hear what other questions or thoughts you all have. Hey, Sarah.
Hi, so just to ask a little bit further on that educational organization side of things, is that do we have to apply officially in some fashion, have some sort of certificate to be considered educational? It's just
it's not an application. So in other words, you're not applying to to any institution or organization to get permission. It's a matter of checking to see what you're offering and how that fits into what the law says, basically.
Okay,
yeah.
Thank you.
Of course. And it actually brings up an interesting thing that I think is worth mentioning, is that I often say there is no copyright police. So it is incumbent upon every copyright owner to enforce their own rights. And that is another reason why a lot of times we see a lot of uses happening that we would otherwise say, hey, they can't do that. But no, the only person who can enforce a copyright is that copyright owner. So it just ends up happening that a lot of enforcement isn't. It's a hard thing to do. It's a lot of time, and most creators are not spending their time being the copyright police. They're spending their time creating. So that's another reason why we see these exceptions to the things that I'm saying aren't being reflected on the internet right now, and that's where there's that gap. One of the reasons there's a gap between the letter of the law and the practice or the implementation.
Yeah, and I think that point sort of speaks to that risk analysis of, I know some people were giving examples in the chat of, well, I'm only showing this content to a very small group of people, it plays into that, how much risk is there. But I think the
Yeah.
example you gave about YouTube videos from 10 years ago is also very interesting. So,
Well, and finding that intern who posted those videos a long time ago is not an easy task. So, yeah, I can tell war stories. It's just, and the point is not to scare people. I mean, the point is not to tell you, to make you never open your computer again. The point is just to make sure we're doing things properly and legally, because it ends up causing less problems. And I think so many. I mean, I know just from seeing who's on this presentation, on this call, so many of us work in the arts and work with creatives. We want to respect those rights. We're not looking for ways to violate rights. It's just that the law is not so clear, and copyright law is not necessarily intuitive. It's not the way you necessarily would think it would work a lot of times, but it's what we have. It's not constantly updated, so it hasn't been updated for the internet very much at all, and certainly not for the world of COVID. And so we have the statute that we have, and we interpret it and work within it to the extent that we can.
So if we have permission from a composer to use work, say an email, do you suggest that we do something more legally official in our files so that they can't come back? And it sounds like somebody could come back in 20 years and say,
Yeah, I mean so here's the thing. This is kind of the shades of gray part of it, in that it is that email, an email license, especially if it's a non-exclusive. So they're not saying you're the only people can perform it. You're saying, yes, you can perform it. There's an email saying, I am the composer. Yes, you can perform this. Have a nice day. That's a license. That is arguably enforceable. The problem is it may not have all those terms that affect, can we use it 20 years from now, right? Does it allow, so we can have that performance. Can we live stream it? Can we record that live stream? Can we post that recording on YouTube? Can we monetize that posting on YouTube? Can we create DVDs and sell those DVDs? And those things probably aren't in the email. So so it's not that the email isn't an enforceable license, it's just not the best way to do it, because it doesn't answer all those questions. And one of the reasons we write things down in contract form is that it should answer questions that come up in the future. I mean, generally, so for all of you out there who have gotten a license, okay, you generally, if it is if it is actually a contract, you printed it out, you signed it, you filed it away somewhere, and you never look at it again because nothing went wrong. They never came after you and said, you can't do that. You knew exactly what you could do, so you didn't have to check it to see. But having it there is, if something does go wrong, if you do have to check it, if you say, wow, we didn't have this thing where you can now view things inside your eyeball. That technology hadn't been invented yet. But now that we can view things inside our eyeballs, is that license allow that? Well, if we have it written down and it says all technology now known or hereafter developed, well then yes, we have that right. But if it only says online streaming and DVDs, then maybe we don't. So
cassette tape.
Cassette tapes, right? Yes, I do still have some cassettes, but I got rid of my 8 tracks. Desiree, I hope that answers the question. I get that question quite frequently, and it is basically it's best to have it in writing if at all possible, just so we can address all those potentialities, all the possibilities.
Cool.
Thanks.
And that actually teed up one of the questions I was going to ask. I've seen a lot of groups that sort of in this moment of closures that are repurposing archived materials. Oh, we filmed this opera that we performed 6 years ago. Let's reshare it. And I think I know what your answer to this is going to be, Dave, but sort of how do you handle that? Like, what if you had all the rights necessary for that live performance 6 years ago, but is it different now posting it on YouTube?
Well, I mean, it isn't. I mean, we oftentimes with legal questions, we say we have to refer to the paper, right? We have to refer to the contract. So when an opera gets permission to do a performance, that is a license, right? There is a contract being created between the whoever owns the rights, and it may be the authors, it may be a publishing company that represents the authors. Generally, it's going to be a company. So the opera company is going to go to the publishing company and say, we want to perform your opera. And the performing company is going to say, okay, here's a license, you can go perform it. And it may say how many performances. It may say it's only good for a year. It may say you can only perform in Denver. It may say you can make a recording for internal archives. It may say you can make a recording and use it however you want. But we do have to go to the license. And one of the added layers, I'll say, of it being an opera is that we go back to all those music rights, because you're licensing to write the composition, but you're creating your own master recording. And when you make that master recording, there is a mechanical license. When you perform, when you display it, when you post it, there is a public performance. So we have the performing rights organizations involved. So unfortunately, I said music is twice as complicated, but these are the considerations for, hey, we have this content, can we use it, basically. I'll also add, and only those in theater will be able to appreciate this, the unions affect this too. And so there are going to be union agreements involved as well.
Any advice for sort of holding partners accountable? This sort of inspired by the question in there about the venue versus the organization that was presenting in that venue, assuming that they're different. I know CBCA works with a lot of different organizations. Some of these groups you're contracting with other folks to provide content. Any advice on sort of how to not just assume that they know what they're doing and are using correct content
Right.
situations?
Yeah, I think that it obviously is very dependent on what that relationship is, because the example, I mean, I think one example that is relevant here is in the theater environment, right? Because of or any sort of live, goes back to live performances, but we often get the question of who has to get the PRO license, right? So if we're performing music in a room, in an auditorium, and does the performing group get the PRO license? Does the organization and generally it's the room, it's generally whoever owns the venue is responsible for the performing rights license, for the performing license from the PROs. And that should be in that contract, ideally, where it says, we're hiring you to perform in our room, we're going to provide the PRO license. It really is, I think it's important to have the conversation about who's doing what and who's got what rights. And hopefully, having listened to this presentation, folks will be a little bit more aware of what rights are in play. And then being able to agree on who's responsible for what, and just put it in writing. I mean, a contract doesn't have to be super long and complicated. A contract doesn't have to have all that legal mumbo jumbo that a lot of you are probably used to seeing. A contract just has to clearly explain what the arrangement is. A contract is memorializing an agreement. A contract has to have, in law school, you learn there has to be offer, acceptance, and consideration. Okay, one party offered to do something, the other party accepted that offer, and there's consideration, something of value is changing hands. That makes a contract. So it doesn't, even it's just said, party A is going to do this, party B is going to do this, party B is going to do this, party A is going to do that. Great, we have a contract. Sign it and we're good. So I think it's really, a lot of this shouldn't be so baked in how to lawyer it as much as it should be in about just how to do it properly so everyone's protected.
Yeah, great. We have a couple more questions that came in through the chat, so I'll just read them aloud. The first is, what is the current law regarding photography during a live performance? And specifically with a drone is in the question, but I think we can even answer that more broadly about either still photography or video recording of a live performance.
Okay. So the law regarding photography during a live performance. So it depends on what the performance is, first of all. And the drone is relevant because there are specific laws around drones. The FAA when drones first came out, the FAA was very upset about this. And you actually had to get an FAA pilot's license to fly a drone, which obviously nobody did. Now everyone can buy a drone for $100. And so that's different now. But there are rules about flying drones. So please, if you are using a drone, please familiarize yourself with those rules, especially in public places. That is important. And so I'll leave out the drone law, but talking about photographing performances is generally going to be okay. It just depends on, well, it depends on the performance. So one of the things we see regularly with concerts, with musical performances, that there are rules around photographers, professional photographers are allowed in, but can only photograph the first 3 songs, for example. Venues will say you can bring in your camera, because we all have a camera in our pocket now that we all carry cell phones, but you cannot, nothing with a detachable lens, basically. So a lot of times the answer is not so much the law, but the rules around the performance itself, basically, and the rules around whoever's presenting that performance. Capturing the photograph of a performance is generally going to be permissible, and generally the photographer will own the copyright in that photograph. The exception is the subjects of that photograph. Because if you, for example, there is copyright protection in set design, okay, or in the artwork that is part of the set design. If your photograph is of that, let's say you take a photograph that's just of the artwork that is the set design, well, that's a reproduction of that set design. So, which is different than it is the entire stage, it is a panel, a shot from further back that gets the whole stage with actors on it. And so it really does depend what's in the photograph also, as far as what you can do with it. So it's a bit of not an easy yes or no question. But generally, I will say that whoever takes the photograph owns the photograph. The copyright law is clear on that.
What if I go to a concert and I take out my phone and I record 30 seconds of my favorite band playing my favorite song, and I share it online because, wow, that was a great concert?
And you are not likely to get in trouble for that. And it is still not legal, but you are not likely to get in trouble for it. I mean, here's the thing, is that you're creating a recording of someone else's music, right? And now, there's a great argument for why it's allowed, because you are adding your creative aspects to it. You may go an angle, you may use a filter, and it's only a short clip. So there's arguments for fair use here. And that is one of the reasons that it's so widespread, and that's why, but there are things that are widespread that we accept that aren't permissible. And the best example I can use when it comes to music is when we first had Napster and Grokster and all those, that, we could first download music, when music first became digital. And everybody went online and started downloading all this music. And then the record companies started suing people in their apartments who were just listening to stuff on Napster. So everyone thought, oh, everyone's doing this, so I can do it. But so this is one of those things where I'm not going to worry about the copyright police coming after you, because there is no copyright police. And we have arguments on why this is a fair use. But technically, according to the letter of the law, whoever wrote that song owns the composition. They have the exclusive right to record it, perform it, distribute it. And if you are doing that, you are using their copyright. Just one of those, it's just the analysis that we look at before we go into a fair use analysis.
Great, thanks. There are 2 questions in the chat, and we will end right at 11:30. Thank you all for those that have hung on and sharing your great questions. First one here. Do you have any advice for libraries regarding reading books aloud on YouTube or Facebook Live as part of a live stream, story time, or something similar to that? Advice on the amount of the book read, how best to handle that example?
That's a great one. So there are exceptions for libraries, but I don't know that it will extend to this. I might have to review the statute, because obviously libraries are doing things, just when libraries were only books, they were doing things with, start putting things online. And we've had to adapt a lot with digital books and audiobooks. Honestly, and I don't know if this would fall into that exception. So I'd have to dig into it deeper. I'm sorry, I just don't know off the top of my head what parameters we can put on this. But you're absolutely welcome to send me an email and we can talk about this and set up a time, because I'm actually really curious. I like this question a lot, and I'd really like to know the answer myself. So I'll post my email and contact information in the chat here, and so everyone can make sure to contact me, because that is a great question, and I'm not sure, and I need to look into it. So I apologize, I don't know it off the top of my head.
That's okay. There's a lot of gray area here. Then the next question is also related to libraries, but different. If a particular performance is gifted to a public library for archival purposes, does the original creator have the right to get that material back for their own archival library?
So this brings up the distinction between ownership of a copyright and ownership of a copy. And the example that is easiest, if you're old enough to remember CDs, shiny things, when you bought a CD, you didn't own the copyright, you just owned a copy, right? And you could gift that CD to someone, you could actually even sell it to someone else, a used CD shop or something. But that doesn't affect the ownership of the copyright. And so when we say a performance is gifted, my guess is that means it's a recording of a performance. They're not gifting the copyright. And if that is the case, then it doesn't affect the creator's right. The creator doesn't have a right to get back that recording. Just like when you buy a CD, the musician can't say, hey, give me that CD back. But it also limits what you can do with it, in that you can't make copies of it, for example, or necessarily post it online and monetize it, things like that. So, gifting to libraries for archival purposes, that's a whole bunch of qualifications in there that may affect this. But generally, I think what's understanding this, and it seems like Shetty says correct, that yeah, there's the distinction between the copyright and the copy. And so gifting or having possession of a copy doesn't affect the ownership or rights of the copyright.
Yeah, if there's only one cassette tape with this perhaps recorded performance, maybe that makes it a little trickier. But as you're saying, Dave, that's a conversation about getting that physical piece, not necessarily the ownership of
Correct.
the copyright in that physical piece.
Mm-hmm.
Is that correct?
Mm-hmm. That's correct. Yep, that's exactly right.
We have a couple minutes left. If there are any other questions, again, that you either want to put in the chat, or if you want to unmute yourself or share them, now is your chance.
Now's your chance. Otherwise, we go dark and go back to our normal lives.
One more question came in. Can you talk about student performances or play-alongs? Are students allowed to post videos of themselves playing along with popular songs that aren't in the public domain? There's issues of, this I think sort of plays into the question often I see of, well, I'm not doing it for commercial use, I'm not making any money off of it.
And I think this also is playing into the educational exception, but doesn't apply to just anything a student does, right? So there's not an exception like now students can go infringe copyrights. It just, and Jake, no offense, like I'm not being flippant. It's just that it is really, I do understand that we're saying, especially because look, I mean, we're all trying to figure out ways to keep our kids busy, right? We're all trying to figure out ways to make this interesting, and I understand all that. But just being a student doesn't qualify for the educational exception. And so I think, and I think one of the things is that posting videos of playing along with popular songs, again, it's like, I know that we are seeing this all over the place. And so I will kind of rephrase or restate that the chances of a student, putting a Facebook Live of themselves lip syncing to a Prince song is not likely to result in a copyright infringement lawsuit, right? If the worst thing, the worst thing probably happens is Facebook shuts down the stream. But I mean, it's still relevant that there is a pretty famous copyright case where a mother had a 2-year-old dancing around the kitchen to a Prince song, actually. I think it was the Let's Go Crazy. And so she videoed her, I believe, daughter dancing around really cute to this Prince song and posted it on YouTube. And the owner in Prince's rights submitted a takedown notice saying that's infringement. And the mother said, no, it's not. I'm putting it back up there. And this turned into a very long and expensive lawsuit. But ultimately, the reason I tell this story is because the fact that it's a really cute kid doing something that is otherwise fairly innocuous does not make it not a use of the copyright. And whether, if that happened today via Facebook Live, probably wouldn't get caught, and probably would have gone unnoticed. But it doesn't make it okay, unfortunately. And that ends up being what it comes down to, is just when we're doing an analysis by the law, Prince's, whoever, whether this is while he was still alive, Prince's record label and publisher probably had the rights. So they owned the copyrights. And this video was using those copyrights on YouTube. And the copyright owner said, you can't do that without a license. So ultimately, you still need a license for those type of situations.
That's a great example. I know most of the folks who have been on today, we've been talking a lot about performing arts, but I feel like I've heard this question come up a lot in like drawing classes of I'm teaching people to draw works that are copyrighted. And
yeah, I mean, here's the thing is if you're making a reproduction of someone else's art, that's violating their copyright, right? As the owner of the copyright, they have the exclusive right to make reproductions. And I actually just today got an email from a woman who is a fine artist, and another artist in another state created reproductions of her art and sold them to a third party, and has videos. I think his Instagram shows images of him with the original while he's painting it. And your reaction, right, Meredith? I mean, Grant, you know enough about copyright because we hang out. You've listened to me talk about these things enough. But your reaction is what the reaction should be. It's like, you can't do that. That's not fair. I mean, the owner of if anybody could do that, why would anybody? But I'll pull back the lens a little bit and say, the purpose of copyright is to incentivize creators to create. Copyright is in the Constitution, one of the very little intellectual property laws in the Constitution, but the Constitution says in Article 1, Section 8, it says that we want to, and basically I'm paraphrasing, encourage the creative arts. And the way we encourage the creative arts is by protecting the art that is created. Because if your art wasn't protected, if anybody could go make a copy of your artwork, then there's no financial incentive to do it, and you have to find another way to make a living. So copyright allows artists to make a living by protecting it and by preventing people from making copies and from duplicating, distributing, performing all those 6 exclusive rights that I posted very early in the presentation. The reason the law gives those exclusive rights to creators is so the creators will be incentivized to create, because they can create, they can know that they'll retain those rights, be the only one allowed to exercise those rights, and therefore be able to make money off of their artwork, off of their creations. So, that if anything helps kind of guilt you into feeling like, okay, fine, I'll get a license, I'll pay for it. That is why we have copyright.
And I think that that's a great way to wrap up today. I haven't seen any other questions come in, and we're just about at 11:25. So thank you, Dave, for sharing all of this good information, thinking through all those different scenarios. Very helpful. Thank you all for listening and tuning in. We are recording this. And do with your permission, Dave, to share it hopefully afterwards with folks who couldn't join us today. And please stay connected to CBCA and Colorado Attorneys for the Arts. We are doing and have been doing tons of webinars and trainings. That is a primary goal for us at CBCA, is to really help advance that creative economy by providing connections to professionals like Dave and others in the community who can share their expertise, as well as we're still providing arts engagement for our membership. We're doing advocacy. We're doing a lot of great work right now, and we're doing it for you. So please stay in touch. Let us know what you need.
Let's also make sure to give a club for CAFTA, because if you do need a lawyer and you feel like you can't afford one, or your organization needs a lawyer and you feel like you can't afford one, coloradoattorneysforthearts.org. It's a very simple application that Meredith will help you out with. If you need a lawyer and you can afford a lawyer, you're welcome to contact my firm, Creative Law Network. But really, we're happy to support, and this is a lot of fun. So thank you all for being here.
Thanks, Dave. All right, everyone, have a good rest of your day.
Bye.
Bye.